Hello, hello. This is Pattyjo. I'm bound and determined to finish Detective Casey's testimony. Ugh. So let's move it along. We're still suffering the cross-examination of the monster.
Do you recall making an attempt to interview the child?
Objection, relevance.
Who was 7 at the time?
Sustained.
Oh, now he's testifying.
Reason for the sustain, Your Honor?
Sustain.
Well, the question was asked, does he recall?
Sustained. Next question, please.
Grounds for the sustain again?
Relevance.
How is it not relevant?
Keep going, sir.
Did you interview the child?
It's
the same question.
Sustained.
Grounds for the sustain?
Grounds for the sustain.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is...
Sir, move on, please. 90611. It's also not relevant. Assumes
very
that's not
relevant.
an evidence.
It was a tricky move. You made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in WAUKESHA County?
You may answer. With the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal...
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
During the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
No.
That is an inaccurate statement.
No. It doesn't say it doesn't say that you can only not commit crimes in the county that you committed the original crime in. But you could go on a crime and murdering spree someplace else. Oh, he's making me start already. Making me yell too. good. What are you looking at?
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
First of all, you can be charged with the same crime, but bail jumping or committing a crime against what you've agreed to, first of all, is a separate crime. And secondly, is not convicting you of the first. You can't be convicted of the same crime. Like, once you're convicted and served time for something, then you can go, and you've professed your innocence the whole time. You can go out and say, yeah, I did that. But you already served your time. That's not bail jumping.
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant,
Grounds.
beyond the scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
So when did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff, or Lieutenant Jerry Habonic.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in, so I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be in the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation. I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
When you referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean
the vehicle was beeping its horn?
No.
Yes, the vehicle was beeping its horn.
Okay. I can't stand that. I can't stand that. A vehicle does not beep its own horn. This is not Christine the movie, okay? Vehicle does not beep its own horn, okay? The operator of the vehicle pushes on the center of the steering wheel, causing the sound of the horn, the sounding of the horn. So, Daryl, you sounded the horn. Ugh.
What would be the only time a vehicle would beep their horn?
Objection,
Never.
speculation.
Grounds.
Sustained.
Rounds.
Calls for speculation.
Look at it. What are you looking at? What are you
Do
looking
you
at?
know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
Because you were pressing on the center of the
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
You asked me to.
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Aggressive?
Do you know that for sure?
No.
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver
He
of
was
the vehicle you
laughing at-
observed was in fact angry?
I assume that he was.
So it would be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold
saw
on,
him?
compound question, ask one.
I was just giving clarification of no,
You
what I
need
meant
to-
by
It's
no.
a compound question. Please rephrase.
Before you observed this vehicle, as you say, and this driver as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
This reminds me, most kids play with matches or experiment with a lighter if they find one and they're not being supervised. And my kids were no different. But my kids always were, kids. And a lot like Daryl being a child. Okay? So I explained to them when I found what I found that they were not to play with anything like that, or they could burn something down and, someone could get killed, like one of them. And they were like, what are you talking about? We didn't do anything. So I escorted them to the back porch where the burnt and melted hamburger bun package was lying on the ground next to the matches. Okay? Daryl is not unlike this. Number one, he really thinks that all of the plethora of evidence that he left did not completely point to him, as you say, when I ran over you, as you say, in the car, as you say, Daryl, we've all brought you to the mountain of burning dookie, which is the evidence of what you spew all over the place, because everything you leave is not flowers in your wake. You leave poop everywhere. Oh my gosh. Prove it. They
Sustained is to the
did.
form of the question.
Hundreds of video.
How would you know how someone's feeling if you don't know who they are?
Your Honor,
asked him to
he
speculate.
opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection.
Grounds.
Irrelevant speculation.
Grounds.
I'll allow it. Based upon his training and experience, he may answer.
It's a possibility.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit. How were you able to obtain that ring footage?
He said it. Got it from your mommy.
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks' mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
Why would she do that? Maybe, comment down there. Why would she give them the ring footage of her son leaving with that vehicle? Why? I mean, not that she shouldn't like assist.
When did you yourself speak to the owner of the owner?
What? Not that you should not cooperate with police. I find, you know, some of these assertion of our rights videos, just, you know, just because you can doesn't mean you should, and you're just irritating and annoying. And on the other hand, I mean, there's certain rules I stick by. You know, if I got pulled over by a police officer, I would provide my registration, license, proof of insurance, but I certainly would not offer where I was coming from or where I was going to. I would not do the sobriety test, more because my knees are kaput than anything else. I'm not going to open myself up to looking like a wobbling fool who can't walk, and getting arrested over that. I might as well be arrested. You're planning on doing it anyway, and then take the tests and show that I'm drug and alcohol free on the back end of that. Those are my choices. I'm certainly free to, you know, assert those rights. But I just question, you don't have to cooperate. You're not obligated to cooperate. You're morally, maybe? But why would she offer video of her own son?
Yeah.
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't recall
Very first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The investigation continues every day. It's not end. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know. I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Ms. Woods multiple times?
Because every time we spoke to her, we got different information, and at that time we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
In other words, Daryl, the only person opening any doors that shouldn't be opened, they were investigating the totality of everything around there. It's a bad example. I do have an example, but it invades somebody's privacy, and I don't want to do that. Once he did this, investigating his life and everything around it, why, motive, that kind of opens up a lot of potential, we need to know these things investigated that they could possibly get. But what he was on bail for, one and or because he's got two bail jumping charges. So one of them is the running over Erica's foot and breaking her leg, or whatever it is that I think he broke her leg and her foot. And the second one was the weapons charge that he used possessed and used a weapon, had two second-degree assault charges against the nephew and somebody else. So they're allowed to investigate that. And, Daryl continuing to ask questions and banging on these doors that the judge has said, no, we're not introducing this. And this is going to bite him. This is going to bite him. He thinks he's in control. He thinks he can ask the questions. What he doesn't understand is it's the prosecution that can't ask the questions. It's this detective that can't answer the questions without going against what the judge has said. He can ask all he wants. He can introduce this stuff. And believe me, he's getting ready to introduce even more evidence against himself.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break I can address it further if need be. Please move on to a new topic, sir.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
No, and he explained.
My testimony before is that those people's cases were not charged.
Daryl, would you like them to be charged? Because endangering people doesn't require you to actually have hurt them. So even the people who weren't hurt, not just the indirectly hurt, but all the people who were there, they could have had that many charges. That would have been nightmare. You're a nightmare.
And were they seen as victims?
Yes.
I'm going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not.
It
Acts
does
to,
not.
acts to his knowledge.
It did not.
I'll sustain the objection as to the form of the question. If you could please rephrase.
He's not going to rephrase. He doesn't even know what he asked.
I'm going to go a different route.
Of course you are. Oh my God.
Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Oh.
Do you recall what that was for?
Yes, I do.
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It was for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-examine. I'll take it up later.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
There you go. No,
Do
I
you
do not.
yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
That is not more specific. That's the exact same question that you just asked. It's just like saying, look at the yellow box. I don't understand what you mean. The yellow box. That doesn't not the yellow box on the table. No, you just asked the same thing using the same words. I think it's clear.
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I would imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it would be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
Yes.
As lead investigator for this matter, are you, to your knowledge, aware of any GoFundMe type of things?
Objection relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
And it would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how
Oh
you've
my
been
God,
present
the
for the
semantics.
whole trial, pretty much?
Can you define extremely for me?
Yeah.
I would like you to define it. Extremely.
I'll answer yes if that helps.
Good point. Doesn't help you. Doesn't help you, Daryl.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in Most larger cases, especially a case of this magnitude, there would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only
Honor.
detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe you said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Is this the zinger?
Objection to the relevance, Your Honor.
Grounds.
He's laughing.
I just want to know his role.
Sustained.
It's rude.
Next
Reason
question,
for the
please.
sustain.
Then
Not
then
relevant.
subpoena him.
He's been in the courtroom the whole trial. Is it not
The
relevant?
who tried. The
Mr. Brooks,
who
next question,
tried.
please.
Nobody knows who he is. That should be known.
Why?
Nobody sits
It's
at
not
that back
relevant to
table.
the
Why?
issues that the jury needs to determine. Next question, sir.
That's your zinger?
Accent? We're telling.
Why, Daryl?
I'm assuming that's asking.
Oh my god. Him and his semantics.
The other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it.
I'd like to get to it.
Please do so. Thank
Get
you.
to it.
I will.
I will. No, you won't. Oh my god. My hair's getting gray as we speak.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this
Good.
matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection.
Grounds.
Legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
Move to
aware of
strike.
that, right?
Go ahead, Attorney Epper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a
The-
legal conclusion in any way.
The court sustains the objection.
Object to the
The
objection.
request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
I thank you. Be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr.
You
Brooks,
stared
under
at?
611, I'm not going to allow the witness to answer.
What? What? Oh, shoot. Shoot. I'm going to pause and get back to that. What was he staring at? I'm pretty close to it.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Okay, it's recording. Okay. All right.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
move to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question.
Oh. I'm having a hard time with my computer.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You
move
are
to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is
Object to
noted.
that.
I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your
I'll
question.
take exception to that ruling
I take exception.
and would like a legal finding of fact.
I swear.
Your objection is noted. It's overruled.
And that's a judicial determination.
Yes.
I think you be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
What are you looking at?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
What are you looking at? What are you looking at? That's gonna be it. Doofus. Okay.
There was no objection.
Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this witness.
They're going to keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're going to
please.
keep coming up.
Under 906.11, sir, please move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will
You
bring it to an end.
you don't gotta keep doing that, Your Honor. You don't gotta keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the truth. They deserve to know the truth.
What truth?
Move to strike, Your Honor.
What truth?
Granted, the jury will disregard
Gra-
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
truthful.
All right, under 90611, I am now stopping the cross-examination. Any redirect by the state?
Objection to that. And I would like
Noted.
a legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the
Tantrum is only
witness
started.
only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take that under
I'm
advisement.
objecting still because
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me see it, and I'll
when
take
did
your
it become an
objection
exhibit?
I'll
It
take the
was never an
objection
exhibit
under
before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead,
I
Attorney
have
Opper.
all the
Book
exhibits.
Go ahead, Attorney Opper. I haven't.
There's a book right there on the desk. See right there? Here. I'll move this. Right here. That tells you exactly the answers to your question. Stupid.
Seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it. Oh man.
All right, you can stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
I'm still gonna object. How is this?
Mr. Brooks, I ask that you honor
I have all
the ruling that I've been
all the
made.
exhibits, though, Your Honor. I have
Mr.
them all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out of
up
the blue?
outside the presence of the jury, but I'm going to allow
Can
it.
that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted. It's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mind-boggling.
Ford Escape. This is the video in which that still photo was taken from.
You could-
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll
And
find that
still
it's
don't know how it
relevant.
was
I'll receive
obtained.
Exhibit 168. Permission to publish is granted. For the record.
It's
Could you
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
Actually, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
Mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
They spelled boggling.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played?
Look at them with their stupid
Is this setting the
hands.
foundation?
It's relevant. You questioned the officer about it. You questioned
I
this
question him
detective
about
about his knowledge.
the still frame from the video. The video wasn't even in the exhibits that I received.
And anybody who's seen
actually
this
didn't
knows
even receive
how
it.
Mr.
Terrible.
Brooks, please
Terrible.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
Bling, bling, pew. With my red scarf on like I'm really included. Look at how long these locks are. Oh my god. There's no way he grew those. Looks like he needs some Ativan.
So play the sound. I want to hear it now.
I'll address that later.
That's why.
Oh, what a derp. Money in his mouth. What is wrong with your face? Where's this mask? Where's his mask when you need it? Look, he's trying to. Oh, what is that? What is the comb over? They just think they're so tough. Are his fingernails long in that too? Yes. And he keeps aiming. Like, that's so tough. Oh, there's the picture. Yeah, got the comb over going again.
Go ahead, attorney, after the video is finished playing.
Thank you. Sir, did you see during the playing of that video the
Fancies
image
himself a
that
rapper.
was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled, foundational. The witness may answer.
Yes, I did.
A lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted.
I
Do you
got
have any questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection. That's
What does
not
that
a
have to
question
do
for
with
the
him?
witness, Your Honor.
That
Sustained.
was a question. The question. When was this
Sustained as to the
video
form of
made
the
an exhibit?
question.
When?
Now, let's be very clear. You stupid goblin. You, Daryl Brooks, made it an exhibit. It was in evidence. Otherwise, they wouldn't have been able to introduce the picture from it as evidence and as an exhibit. Evidence and exhibits apparently are two different things. When you questioned his credibility on being able to identify the picture in the exhibit that came from the evidence, which is the video, you made it necessary for them to regroup with and prove his credibility by showing the evidence and making it into an exhibit so the jury could see that the original exhibit came from evidence and it's clear that it's you. So, Daryl, you made it an exhibit, single-handedly serving it to the jury.
Was this video made an exhibit? That is a question.
Exhibit. That is a
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did you
the
see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Casey.
for tantrum.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I don't know,
It would be
Daryl.
the same thing. I
Are
take
you
that as
breathing?
disrespect because they were allowed to say something, and I said under my breath that was disrespect.
Well, I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can you do that, please, and acknowledge them? Because I'm always the one getting admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
Yeah, what does the camera have to do with people
I'm
seeing?
advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Maybe he's a fan. Maybe he's a fan.
Today.
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to
Because I'm a fan.
review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained as to
was
the
not
form
brought
of
up
the
in the
question
early
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I'll stay with my
Objection, objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
There's his zinger.
Objection, assumes facts, not in evidence.
Sustained as to the form of the question.
There you go.
This is mind-boggling.
This is mind-boggling. Mind-boggling. I don't know what he's looking at, but
Can you
it's
clarify again why
mind-boggling.
you viewed the video this morning?
objection asked and answered.
Sustained.
So you're gonna sustain everything?
It was already
No,
answered.
she's going to sustain everything.
Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people is trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked.
Because you asked. Thug.
That's the only reason. Because you asked.
Asked. Did you see me be a
See
thug
what
in
you
that
people
video?
are trying to do. It's not right.
Thug.
It's not fair and it's not right.
Can't believe it.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Opera, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
Because I'm rude.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would.
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Yeah.
Mr.
why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video. Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course it's ultimately up to the jury to determine that, and what relevance, if any, that evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it, because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it relates to that.
What do you mean by it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment?
Because you made it. You just explained the whole thing.
That was the issue. The issue.
She just explained the entire way it was made into an exhibit. She just explained it. Ugh.
Offer of proof on that, because obviously they marked it as an exhibit.
Well, with all respect, Your Honor, you're mischaracterizing what I already said, and the record needs to be clear. The issue that I raised was how did this, at the last minute, out of the blue, become an exhibit? That was the issue.
Go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware.
He said social
there's
media.
nothing
he didn't say what it was.
Sir, Stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
I'm gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here.
She's not
So
wrong.
I apologize
apparently.
for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Okay,
Okay.
So, she made a very strong and intelligent, though impassioned, set of remarks that support her introducing this. Now let's hear what Goblin at Law has to say.
record being made,
I object to that.
my previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about.
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present.
Who cares
it doesn't.
what you think?
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations.
First of all, Daryl, yes, you are an idiot. Yes, you are. You are indeed an idiot.
I didn't say you, Your Honor.
No. What I've observed
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
She's such a narcissist.
That is very disrespectful to me.
It is not about you, you narcissist.
I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole...
That is so disrespectful. She is an attorney. She is an educated woman. You're the only one doing that.
Time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's this trial.
I'll take that.
Do you have anything you want to put on the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said.
That's not what she
just
said.
Made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm not
What do I need legal basis for when she just admitted on the record that she just made this exhibit up
right now? That is a complete mischaracterization. Sure, she did not
That's what. So she wasn't
Create
implying that by saying that she
exhibit.
could
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of speech.
Okay, so what is
Right.
it implying to? What would that be implying to?
As attorney,
How would anyone?
all right,
How would
I'm
anyone in
moving
my
on
position?
because you're not providing
How
me
would-
with any
how would
legal
any-
basis.
I didn't even finish.
For me
You told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything-
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
you're
wouldn't get to
providing
that if I
commentary.
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the
On
legal
what
basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're
absolutely
talking about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I had
this
done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please.
you mean? I'm asking. What do you mean?
Mr. Brooks, you continue to
That is
come at
not.
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it relates
asking
to
me
other
to do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing it
Mr.
to
Brooks, I'm
judgment?
only going to ask you one more time, and if you
I'm
don't
saying
answer it
if I don't
correctly,
understand,
then
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Damn.
It calls for
I don't
a
like
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks?
appreciate it.
Sit down. I don't care if you don't like my
I'm
tone,
not
but
gonna-
you've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost
So what?
of respect
No,
for
you haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you
don't.
want to call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's talk to
now.
each other like adults then.
Well, okay.
Because I've never told you to stop
First
talking.
you.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the jail,
No way.
the search of your jail cell? Yes or no?
what was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answering
cell?
my question. We'll move on.
I'm trying to understand. If I
Now,
don't
we're gonna take a
understand,
break.
how
We're
do
gonna
I know?
recess 15.
If I don't understand, I can't. Daryl, can you are not running this. It is not about the submit. The narcissism is just the, ugh.
How do I know what I'm supposed to answer if I don't understand? And I don't agree to a stop.
An estoppel. Well, I agree to an estoppel. My God. What an idiot. Bless you if you stuck it out to the end. Oh my goodness. Thank you. Like, subscribe. I'm not even going to draw this out any further. Like, subscribe, and comment. I will talk to you later. This is Patty Jo. Bye.